So good morning. Welcome to Herald Inside LI. I'm your host, Sky. This show is produced by Herald Community Newspapers, a Nassau County-based weekly subscription newspaper, and Richner Live events. Each week, we explore another topic or industry impacting Long Islanders. And today's episode will focus on two specific topics that concern many people. And we have two experts with us, Stephanie D'Angelo, who you see on the screen, and Frank D'Angelo, who will be joining us in a little bit. And they're from these two different industries, and they're here to discuss it with us. The fields are estate planning and the ways in which the industry has changed in response to COVID-19 and some of the federal tax implications that come along with the new presidential administration, and the 2021 Medicaid planning for aging and illness. So those are the two things we're going to focus on today. And I just want to take a moment to thank our sponsors, Family Care Connections, LLC, providing comprehensive healthcare management, information, counseling, and advocacy to individuals and families, as well as D'Angelo Law Associates in Garden City, a law firm specializing in trust and estates law. So, as our audience may know, the way we usually do these webinars is with a panel of experts, but today I'm fortunate to have with us one expert in each field. And like I said, our audience submitted a ton of questions. So we can just dive right into the discussion, and the format will be a little different than usual. Instead of having Q&A at the end of the hour, we're going to have 30 minutes with Stephanie, who you see here, with some time for Q&A, and then 30 minutes with Frank, including Q&A. So audience, if you have questions this time, just don't save them till the end. You can use the Q&A function at the bottom of the screen to type in your questions, and I'll pose them as we go. And as usual, I try to get to everyone's questions, but if we don't have time for them all, I'll just ask the ones that may apply to most people. So think broad rather than specific. And for anyone with an undying specific question, our panelists have been generous enough to offer their contact information. So everyone will be emailed their contact details after this webinar. So you can feel free to reach out to them directly. And as a reminder, today's episode is recorded, so you can always refer back to today's webinar, and it'll be posted on our website at liherald.com/insideli. So without further ado, I'd like to introduce our first panelist, Stephanie D'Angelo from D'Angelo Law Associates. And Stephanie, if you could just give everyone who's tuning in just some background on who you are and what you do before we dive into some of these questions.
Yes. Hi, Sky. Hi, everybody. I just want to say hi to any of my clients that might be tuning in too. My name is Stephanie D'Angelo. I am a trust and estates attorney. I focus on trusts, estates, protecting your assets, and helping your family really at a pivotal point in people's lives when you're thinking about taking care of your loved ones and when you're thinking about passing away, right? I have been working in this field for over 10 years now, believe it or not. And I've been an attorney now at managing this firm for the last 3 years. So we really focus on how to help you and how to help manage your family.
So should we dive in?
Yeah, let's dive in. So, I figure that people probably are either tuning in because they might know some about this already, so they might need a refresher though. But there might be some people who are just dipping their toes for the first time. So I kind of wanted to go over, a quick summary of what a comprehensive estate plan is. So first and foremost, there's really 3 categories with 4 documents in total that you really should have to have the full protection that you need, right? So there's your health directives, and that actually has 2 documents in that category. There's your financial directives, and that's really, 1 document. We'll go over those. And then there's finally your last will and testament. Now, your last will and testament people probably know about. That's your directive of how you want your assets distributed, all your stuff distributed when you pass away. That only comes into play once you die. The other directives, your financial directives and your healthcare directives, really take care of you while you're alive. So let's start with your healthcare directives. That's your healthcare proxy, which appoints an agent, somebody to act on your behalf to make healthcare decisions for you while you're still alive, and if you're unable to make those decisions yourself, okay? And then the next one is your living will. And it's a terrible name because it really sounds like it has to do with your last will and testament. People get very confused by that, but it has absolutely nothing to do with distributing your assets. It's just about making the decision on how you want to be treated when you're dying. And you appoint your healthcare proxy, and this living will acts as in your place to make those decisions for you when you can't make them yourself. Okay. And then there's your financial directives, and that's really your power of attorney, right? Everybody's probably heard of that a little bit. It allows somebody to manage your finances for you. Now, particularly about that document is people get confused because what happens is you're appointing someone to manage your finances, but it is immediately effective, unlike with a healthcare proxy, where somebody is appointed and only when you can't act or you can't make those decisions is that healthcare proxy agent able to step in for you. With a power of attorney, they can step in immediately. So people get a little nervous when you're signing that document, and you should be very careful with who you pick. But there's a lot of changes and ways we've addressed, executing these documents and being sure that they're effective since, we're talking about the pandemic. So since COVID-19 started, and that's really where I think we should jump into next is what have been the responses in our area of law to.
But before you dive into that, I want to touch base and circle back on some of the things that you mentioned already, because we got questions. For example, what are the reasons why everyone should have a will? And what happens if you die without having a will?
Okay, so everyone should have a will. If you have a bank account to your name, having a will makes it much less difficult to be able to distribute your assets once you're gone. If you don't have a will, we have to go through a process called administration with the courts. Right now, kind of what's been going on with the courts since this whole pandemic started is kind of, the courts are doing their best to adjust, but it has been extraordinarily slow with addressing all the people that have passed away and all the different scenarios, right, with or without a will. So without a will, you go through something called administration, and your assets are distributed according to the law, meaning you don't really get to decide who gets your assets. If you want your friend to get it, if you want a particular family member to get it, more assets than another, it just goes in the way that the law dictates. With a will, you can decide who gets your assets and how they get your assets. Also, it takes much less time because we go through a process called probate. It is usually a quicker process. So with a will gives you the ability to be able to distribute the assets the way you desire them distributed. Without a will means it's going to take a lot longer with the courts, and you don't get to decide anything.
So that process that you mentioned, when someone does have a will, what is that process when someone dies? How to access the will? What exactly needs to happen?
Right, so that process is called probate. So it's the process of submitting the will to court and getting their permission, the court's permission, saying that they're certifying the will is authentic. Okay, and then once you get that certification, you get something called, instead of a regular order from the court, right? It's called letters testamentary, and that is the authority to be able to distribute assets according to the will. So first you have to get that certification through probate. You need your original will, and people need to remember that having your original will is very important. And also it should be stored correctly, right? It should be in good form. It shouldn't be written on. It shouldn't be teared at. That can invalidate a will completely. And staples should not be removed. People don't realize this. I had a client recently come in, and a wonderful client, old client of ours, come in and, had taken out the staples for his mother's will because his family members wanted to see the will. And so he made copies, and that was a huge issue, so that's something that you'd have to discuss with your attorney. But in that scenario, regardless, now don't make that mistake. Do not take out the staples.
Why?
This area of law, we are always looking, or it's very old, right? This is one of the oldest areas of law. So they're always looking to be sure that someone actually intended to distribute assets in the will and that it's authentic, right? So if you've teared up the will, if you've written on the will, if you've removed the staples, then what happens is that the court says that you probably actually meant to destroy this will. You didn't want it to be distributed that process anymore. Okay. So, right. So that's, it's tricky, but people don't make that mistake. The staples are important, and keep your will in a safe at home, fireproof, waterproof box. You don't want it to burn up. You don't want it to get soaked by a flood, whatever could happen. Okay.
Yeah. And I learned recently that a will needs to be notarized and there needs to be witnesses that sign the will. Because my father has always said that he has a will and it's a piece of paper in his drawer that he signed himself, and that's it. But that's an invalid will.
Right. Absolutely. Just because you wrote something out does not make it a valid will. And, technically in New York, you can, if you have witnesses and you have a notary, it can be possibly a valid will, but it is not presumed valid. When you create a will in New York with an attorney, it is presumed to be validly executed. So you want to create one with an attorney, and it's important that it's done correctly. You should see an attorney that really focuses and specializes in this area of law, because you can easily create a document that isn't valid.
So that actually gets into another question that came in, Stephanie, about, do all estate planning, living wills, power of attorney documents, et cetera, have to be done through an attorney or filed with one? Or could you do this with some software online or on your own?
So that's an important question. And people always are looking to try to save money here and do it on their own. But the likelihood of you messing this up and not properly creating these documents is very high. You could, there are softwares that exist that allow you to try to create it on your own. And I've had clients come in with their own last will and testament, with their own healthcare proxy, living will, with their own power of attorney. And 99% of the time, or 9 out of 10 times, I would say most of the time, almost always, they're improperly done, right? They either make no sense, they don't actually follow the rules that's required for execution, or they're just completely invalid and have to do with maybe another state or sometimes another country. They don't follow the rules. So it's best if you see an attorney, especially if you have, people need to think about that. If you own a home, if you have kids, if you're married, you should really see an attorney and go over your estate and have a conversation, an individualized conversation about your assets and what needs to be done to manage those assets while you're alive, and then also distribute them once you're gone.
And another question that came in from an audience member named Candy, she asked about a beneficiary designated, like for a 401k, and what's the difference in designating a beneficiary versus having a will? If you don't have a will someone still be able to benefit from 401k, for example?
Absolutely. Hi, Candy. Certainly appointing a beneficiary on an account is important, especially for, accounts like 401ks or IRAs, where if you appoint a beneficiary, there might be certain remedies or legalities that might actually be more beneficial for an individual in that situation. A will can address that as well. Trust can address that as well. But those are other ways to actually avoid the courts at the end of your life. Okay, so in that situation, someone would not need to probate for that particular asset. Now, that doesn't mean that they wouldn't have to probate otherwise for your other assets, but for that particular asset, it would avoid the courts.
Okay, so I know that right before we dove into this wills question, you were going to talk about estate planning and how some of the laws have changed both in the state and maybe federally when it comes to estate planning. So Stephanie, if you want to give us some background on that, otherwise I can dive in. I have some questions that came in specifically about estate planning and trusts.
Okay, wonderful. Let's go into what's changing this year. There's a few changes this year. Your durable power of attorney. We talked about power of attorneys before. We mentioned that it's your financial directive. It appoints somebody who you trust, right? You really have to trust them. That's something that's with all of this. You're appointing fiduciaries, people who are going to be able to manage your assets, people who will have a lot of responsibility over your life. So we want to make sure we give somebody who can handle that, the ability to do that. But there's some big changes this year. Governor Cuomo signed into effect a new statutory form for the power of attorney, and it's going to be in effect. And what it does is it really tries to streamline the process of the power of attorney. It actually tries to make it so that financial institutions won't not accept the power of attorney, which is really usually the issue, right? With all of these documents, you want to make sure that they're really well prepared, which is why you see an attorney who specializes in this field. Because if they're not prepared correctly, they won't be accepted by a healthcare institution or a financial institution or the courts, right? So sometimes when you go to use this power of attorney, a financial institution might give you a hard time. They might not accept it. So this new version tries to address that so that they can't just kind of carelessly ignore your power of attorney.
Now, some of these questions are a little specific, so I'm going to ask them. Can you discuss how to handle the estate planning process when you have an adult child with disabilities?
Right. So an adult child with disabilities, you should certainly always seek, individualized counsel when you have someone who has a disability. Okay. So in general, there are certain things that you would need to discuss, right? You might want to look into getting a power of attorney for that individual, right? Your child. If you don't have a power of attorney, what you have to do, and this is with any situation, right? If you wait on any of these documents, that's why you're planning when you're good, when you have the capacity to execute these documents. If you don't have the capacity, or if your child in this situation doesn't have the capacity, you have to get something called guardianship over that child. And it's not a fun process, it's a court process. So, and really at the end of the day, you still want power of attorney. So if you can create that and your child has the capacity to sign that document, wonderful. That would allow you to manage their finances. You should also discuss supplemental needs trusts, also known as special needs trusts. So trusts to protect your child's assets or anything that they might inherit, so that they can still possibly qualify for government benefits related to being disabled. Additionally, that healthcare proxy and that living will. Again, anybody 18 or older, you need a healthcare proxy and living will for them. You can't just make healthcare decisions for your family member in New York. It seems strange, but you absolutely need that healthcare proxy and that living will. And that's another reason why you see an attorney for that. Because when you see me, it's durable, right? It's effective unless you revoke it. If you sign these healthcare proxies at a hospital, it's only effective for that particular reason that you're in that hospital or for that time that you're in that hospital. It doesn't remain effective, okay? So that's what you would really want for your disabled child, but also that goes into a little bit of, for your family members in general.
And what about a trust account with restrictions? Is that something that you can help with? An inheritance and a trust with restrictions?
So you can always see an attorney and create a trust that has restrictions. It depends what kind of restrictions that you want. Does it say anything specific about the restrictions? Is somebody kind of...
No, just restrictions in general, I guess.
Okay, so restrictions can be a lot of things. I have clients who come in and say, I want my kid to inherit, X sum of money or X percentage of my estate, but only if they go to college. They have to graduate with a college degree. And so we can certainly put that into a trust or a will to be sure that they inherit if they meet that requirement. Sometimes it's, even, more dramatic requirements. It can be that they have to have gotten a certain GPA, right? Which happens once in a while, right? Or they have gotten their master's degree, or they've established something of themselves in general. A little less specific is they can inherit at a certain age, right? So somebody might inherit instead of at 18, which is when you're legally able to inherit, you would inherit at 25 or 30, and a year or an age where you'd be more responsible with your money, right? That's what we're always hoping, is people are responsible. But yeah.
No, I was going to say, because we're talking about when you leave things to people in a trust, to your descendants, to your children. Olga has a question about beneficiaries not being US citizens. They live in another country. What can she do to transfer her assets to her or make her will valid?
Oh, okay. Hi, Olga. So in that situation, you should certainly see your attorney to discuss what the legal implications there are when you're dealing with other countries, when you're dealing with beneficiaries who may not be US citizens or may live outside of a US territory. That's an important thing to discuss with your attorney, and you should seek individualized help for that.
Okay, we have a lot of questions here, and some of them are very specific. So I am going to skip over some of the extremely specific ones and encourage everyone who's listening to please reach out to Stephanie. Again, today's episode of Herald Inside LI is being recorded. So you're going to receive in an email recording of today's episode and Stephanie's contact information. So let's go over some of the maybe broader questions that could pertain to more people than these specific situations. Stephanie, how would you suggest individuals speak with elderly relatives about estate planning?
Oh, wow. That's a very important question. And I think it's a difficult conversation for some people, right? If it's your parents, you're thinking about a horrible situation where they're going to be gone. We all know theoretically our parents, our loved ones, they're going to be gone one day, but it's very tough to talk about it. If your family is not the type of people who discuss these things, then you might want to schedule an appointment with an attorney, sit down with them, talk, get this kind of information, exactly what I'm telling you, and then go to your parent, go to your elderly relatives, sometimes it's aunts, uncles, sometimes it's just your friends, and discuss with them what they need so that they can be taken care of, right? Because first and foremost, we want to take care of somebody. As they age, if they get sick, that's what's most important. Distributing your assets is extraordinarily important, and it's something that should be discussed. But sometimes the best way to dip your toes is talk about taking care of them and how you're concerned. But there are plenty of other ways. So that I find, though, is very helpful.
Mm-hmm. And what about some of the tax implications? I know you touched on how the laws have changed, and that means some of these tax laws have changed also, which I know comes in with the new presidential administration. But the question was, when putting assets in a trust, do they come out of your estate so that they are not subject to the estate tax?
Oh, so that's a very complicated question, and you should certainly see your attorney, right? If we're concerned about estate taxes, you need to sit down with your attorney. Generally speaking, right now in New York, an individual isn't taxed until they're have well into the millions. For couples, it's doubled. So we're talking, $11-12 million before you have to be concerned about estate taxes in New York. Now that doesn't have to do with obviously IRAs or 401ks. Those things can be taxed because there's capital gains, et cetera. But for an estate tax or a death tax is what people call it too, you don't have to be concerned about that right now until you have well into the millions. And that's at the New York level. Now at the federal level, it's $11 million per individual, a little bit, give or take a few $100,000 there, but it's about $11 million per individual. So $22 million before you have to be concerned about federal estate gift tax, okay? You have to have a lot going on there. And although some individuals do fall within that, and that's when you absolutely need to be planning, probably every year, at least every year, I would say, but at least maybe even 6 months or 3 months, you talk to your attorney. For all of us other people who are successful, hardworking, we don't have to worry about that. But who knows what's going to happen? Again, you brought it up, Sky, that change in administration means this law can completely change. 10 years ago, it was $1 million. You just had to have $1 million and then you would get taxed. Now, on Long Island, especially right now, all of our houses have shot up in value. So sometimes, we're worth $1 million just because our house is suddenly worth $1 million. So in that case, if that law changes in that way, you'll get kind of a blast, an email blast from all of us, letting you know that it's time to sit down with us and talk about what we need to do to protect that asset.
Mm-hmm. Okay. Now, when you talk about assets, there's a question: what happens if someone doesn't claim an inheritance? If they're left an inheritance and they don't claim it, is there any way to look up a deceased relative's unclaimed funds?
Oh, that's an interesting question. So if somebody doesn't claim an asset, there's always unclaimed funds, right? In terms of somebody needing to, you finding out that maybe your family member who deceased, right, had unclaimed funds, you would have to get authority over their estate, and you should see your attorney about that in order to claim those funds. But let's say you have an individual who is a beneficiary and you can't find that beneficiary. There are ways to address that. Your will should address that anyway, by saying if somebody's not alive, then it either goes to that individual's issue, right, their kids, or if they don't have any kids, then it goes to the other beneficiaries in your last will and testament. But a thorough search should be done to find that individual or any of that individual's beneficiaries.
Now, here's a question about different types of law firms. Henry asks, can you address the pros and cons of using a larger versus a smaller law firm?
Well, there's pros and cons to really who you're dealing with. You should find an attorney who you feel comfortable with, right? Who you trust, right? There's a two-way street with trust. You have to sit down with an attorney, feel comfortable talking about your family, your finances. You really get into the nitty-gritty with your finances. I have clients who bring in all of their financial records, and we sit down and we go through everything. We keep an inventory and make sure that we're aware of everything that goes on every year. So you have to feel comfortable with whoever you're seeing. It doesn't matter if it's big or small. It should be someone who you feel you can trust. And, we want to make sure that we trust you as our clients too, that we have a good relationship with you as well. So look for an attorney who you feel comfortable with.
So I know that we're nearing the end of our time together, Stephanie, and there still are a lot of questions here. Some questions specifically about revocable versus irrevocable trusts and controlling the money and how to protect assets while still maintaining control of them. So you tell me if you want to dive into those questions or if there's anything else that you wanted to touch on before we transfer over to Frank and the Medicaid side of things.
Well, I can certainly kind of give you a little bit of an idea of revocable versus irrevocable. In general, those are really the broad categories for trusts. In irrevocable trusts, usually, and this isn't always true, but usually it provides a way to protect your assets by separating the assets from you. And a revocable trust is more of a way to avoid the courts at the end of your life. Now, if we start to get into the nitty-gritty of trusts, you really should see individualized counsel for that, because that's where an attorney is going to decide what makes sense for you. In terms of Medicaid, and that's kind of where this conversation is going to go without me, you'd see me to talk about trusts to become eligible for Medicaid, right? You see me to protect your assets, to talk about how we can protect your assets, to be sure that you're eligible for Medicaid, either now or in time. And it could be just not for you. I have children who come in, and children, I don't mean young, I mean their parents are getting old and need care, and they come and see me, and that's when we discuss starting to protect their parents' assets or making individualized transfers to be sure that things are going okay for them. And then you would see my father, Frank, who's going to be on shortly, to be sure that you get Medicaid, right? He's the application process. I'm the head of time. I'm the let's plan in advance. Let's get this done. Let's protect those assets.
So thank you so much for sharing your wealth of knowledge with everyone today. And like I said, today's episode is recorded. So everyone who's paying attention now or who signed up for this webinar will receive a copy of this video in email along with Stephanie D'Angelo's contact information should you have any additional questions or you would like to see her as an attorney. So Stephanie, thank you so much for your time today.
Sky, thank you. This is so fun. Have a great one.
Yes, you're welcome. And now we'll segue into Frank D'Angelo to focus on all questions related to Medicaid.
Thank you for having me, Scott.
Welcome. Hello.
Having me, Sky. As you know, I'm with Family Care Connections LLC, and we provide advanced practice nurse care management, geriatric care management, Medicaid planning, elder care consulting, and housing options for aging. So it's a comprehensive service for people who are contemplating many of the issues that people face as they're aging, and in conjunction with what Stephanie was discussing before with the legal planning. Before we begin, I just want to state that the information we're giving is really informational, and I don't want anyone to think that this is legal advice or personal advice, but rather it's information that would help them to begin to think about their personal situation and then take it to the appropriate professional of their choice. So in the context of that, I'd like to talk a little bit about Medicaid eligibility and some of the updates with respect to Medicaid eligibility. And using the same format, I guess you could just pipe in and ask some questions as we go along, okay?
Hey.
So, Medicaid is basically a means-tested program. You have to have limited income, limited assets. But contrary to what many people believe, it is possible for middle class and upper middle class people to qualify for Medicaid, particularly when they're suffering from a serious illness, a catastrophic illness that might require long-term care, whether it's at home or in a nursing home. And the way you do that is by transferring assets. So a lot of what we're going to discuss today is the rules around the transferring of assets. But in order to really understand that, we have to know what the levels, the threshold levels are. So the first one is the income test. You can't have more than $890 a month in income to qualify for Medicaid. But fortunately, New York is what's called a spend down or surplus income state. So if you have excess income above $890, it's possible to still qualify by transferring some of your income into a pooled trust or spending down your money on health-related expenses. And we'll go back to that in a few minutes. Second piece to the equation is the resource threshold. You can't have more than $15,900. These two numbers, the 890, 15,900, the 2021 numbers. So they just went into effect last month in January, and they get adjusted every year. So it's important if you're involved with Medicaid planning to find out what the new number is for income and resources every year, because it changes at the beginning of each year. So $15,900 is the resource threshold for a person to qualify for Medicaid. So in order to understand Medicaid, we really have to break it out into two aspects. One is nursing home Medicaid, and the other is home care Medicaid. Mm-hmm. Nursing home Medicaid obviously is the kind of Medicaid people think about when they have a family member or loved one who needs to go on long-term care in a nursing home facility for an indefinite period of time. Normally, if you have a hospitalization and you require skilled or rehabilitation care after that stay in the hospital, and you're a person who is aged and you're on Medicare, you can get coverage under Medicare for up to 21 days in a post-hospital rehabilitation facility, and it will be paid in full for that 21 days. Mm-hmm. For the remaining days, up to 100 days, there is a copay that each individual is responsible for, and it's roughly 20% of the daily rate. And again, that number gets adjusted every year. After the 100 days, people are faced with the situation of how do I pay for the nursing home stay, which could be as much as $15,000 a month. Mm-hmm. And the way you do that is by transferring your assets. However, under nursing home Medicaid, there are limitations to how you can transfer your assets. So many people are familiar with the 60-month look back or the 5-year look back limitation.
Right.
Because the general rule about planning for or qualifying for nursing home Medicaid is that you can't transfer your assets, or when you do transfer your assets, you have to wait as long as 5 years to qualify for nursing home Medicaid. Now, that number is not quite as severe as that sounds, because under certain circumstances, it's possible to qualify sooner. We're not going to get into the complexity of that during this seminar, because we'd spend an hour just going through that particular issue. But I want people to walk away with the understanding that you can qualify for nursing home Medicaid for less than the 5-year look back. But you'd have to look at the specifics of your situation. The general rule is there's a 5-year wait or 5-year look back period. And during that period, the best way to understand that is there's an audit period where they'll look to see, have you transferred assets? And if you have transferred assets, they will impose a period of ineligibility on your Medicaid eligibility for nursing home Medicaid.
Mm-hmm.
There are certain exceptions to that limitation or that rule. One is you can transfer your assets to a spouse, unlimited amounts to your spouse without a penalty. So a good way to understand that is if you have a spouse who's ill, you can transfer your assets to the well spouse and not have to worry about the 5-year or the 60-month period of ineligibility. You can also transfer your assets to a disabled child. So back to your question before that you had for Stephanie about doing some planning for disabled adults.
Right.
One of the things that you might be wanting to do in the context of planning for a disabled adult child is think about doing some transfers into a special needs or supplemental needs trust for that disabled child, and understand that when you transfer those assets, you're circumventing the 60-month look back period or period of ineligibility.
So, Frank, so I know for me, I'm not an expert, you are. So yes, a lot of the information seems overwhelming. So maybe if anyone feels overwhelmed, I want to reiterate to our live audience that you can type in questions as we go along and Frank will answer them for you. But Frank, you just touched on the 5-year look back period and then transferring assets. And 2 questions that came in were, can you please address the asset transfer look back period and what assets should and shouldn't be transferred? And then you may have touched on that in what you said, but I wanted to pose that question to you in case there's something more specific you wanted to go into. And the second question was, please talk about the 5-year look back period and how that could affect financial aid and where to place extra assets. And maybe that's what you mentioned with transferring it to a spouse or to a child.
Right. So just to re-emphasize, the rule is if you want to qualify for Medicaid, nursing home Medicaid, you can't have more than $15,900. So most people are faced with the dilemma of, okay, what do I do with my excess income? And if you transfer your assets to someone other than your spouse or a disabled child, you're facing the 60-month look back or audit period and a penalty depending on how much money you transfer.
Okay.
The limitations on what you transfer, obviously you need to transfer all assets. If you're faced with that situation, you need to transfer all assets that will enable you to qualify for Medicaid. Now, there are certain assets that don't get applied to the $15,900 amount. That includes tax-deferred investments like IRAs, 401ks, or tax-deferred annuities. So the general rule for Medicaid is if you have those kinds of assets, they're not going to count that as part of the $15,900 equation. But what they will do is look to see how much income is generated from those tax-deferred investments and apply it towards that income rule that I talked about before, the $890 a month.
So what are the tax implications? This is a question that just came in. What are the tax implications on the person that you would transfer the assets to?
Well, there is no tax, gift tax in New York. So you can transfer the assets to an individual or to a trust. Of course, you would consult with your accountant before you finalize any of these transfers to be sure that you're not triggering an unforeseen tax event. But generally speaking, the recipient of those assets doesn't pay tax. And the grantor doesn't usually pay tax, except if they have very large estates, as Stephanie touched on before, because you could trigger a tax problem if you're doing massive gift tax to somebody, and your estate is a federally or New York State taxed estate. But generally speaking, when you're doing these gift transfers to individuals, and obviously a transfer to your spouse is exempt from all of those tax triggers, but if you're transferring to someone other than your spouse, generally you're not really creating a tax problem unless it's a tax deferred investment, as I described to you before, in which case you should always consult with your financial advisor and your accountant regarding the tax implication. And then you gotta have to balance the implication of being able to qualify for Medicaid sooner rather than later versus what the tax consequence would be.
So speaking, because you mentioned tax deferred something, Melissa asks, can you transfer a tax deferred annuity into a brokerage account so you can have access to the funds for medical expenses?
The quick answer is you'd have to talk to your financial advisor who's managing that annuity to know what the parameters of the investment are, to see whether or not you could transfer it and under what circumstances and the type of investment you can transfer it to. But my experience has been that oftentimes you can transfer those accounts, but if it's tax deferred, you may be triggering a tax liability now at the time of the transfer. So you need to be real careful, speak to your financial advisor and your accountant to understand the implications. But for Medicaid, I just want people to be clear that if it's a tax deferred investment, you don't necessarily have to transfer that asset out to qualify. You just have to factor in what income is being spun off from that investment and factor it into the equation on the income side of Medicaid eligibility.
Okay. And speaking of that Medicaid eligibility, you mentioned the $890 level, and Henry has a question about, can you transfer pension and or Social Security income to qualify for the $890 level?
Right. So generally, Henry, you can't transfer your pension. What you can do is to qualify if your income exceeds the $890 a month, what many people do is they look to a special kind of planning tool called a pooled income trust. A pooled income trust is a trust that you set up with a not-for-profit organization, and there's a multitude of them out there, and you set up this pooled trust, and your income goes into that trust, and you identify your monthly household expenses, and that income might include the pension or the Social Security income, and you identify the monthly income and the expenses, and the expenses get paid out of this pooled income trust. The pooled trust manager charges a fee to set up the pooled trust, and there's a range of that, but it's generally around $300 to set it up, and they charge a monthly fee to manage it. But what it enables you to do is it enables you to take that excess income above the $890, whether it's from a pension, Social Security, an IRA, a tax-deferred annuity where you're getting a distribution, and apply it to your household monthly expenses that are necessary, like your utilities, the cost to run your home, et cetera. But it still allows you or your family member to qualify for home care Medicaid.
So, Frank, is Medicaid different in each state?
Yes, Medicaid is different. Primarily, Medicaid is a federally funded program. That's why you probably hear a lot, when you're listening to the debates going on in Washington about the cost to fund Medicaid. And even under Obamacare, there was a great deal of discussion about creating or expanding eligibility for Medicaid across the country. And traditionally, what happens is Medicaid, each state gets a block grant of funds, and the federal government dictates certain parameters for eligibility. But above and beyond that, they say to each state, if you want to have a more expansive Medicaid program, then you have to pay for it. So Medicaid in New York is traditionally much more liberal, much more expansive than other states. For example, we have a very comprehensive home care Medicaid program. Some states don't have much of a home care Medicaid program at all. Many states don't have this surplus income provision like I just described to you with the pooled trust. They have a much more strict criteria where if your income exceeds the limit by even $1, you don't qualify. But what's happening is, fortunately, under Obamacare and as the Affordable Care Act begins to evolve, the states are realizing that it's really advantageous to allow for more expansive Medicaid programs, because more people then qualify for the care, and the federal government is willing to subsidize more of that than they had been in the past. But it does vary from state to state. So if you're a person who, one of the key components to this whole program is you have to be a resident of a particular state. So if you're doing the planning in New York State, you want to make sure that New York is your place of residence, and that's where you really intend to spend most of your time and you receive the care. Because if you're a snowbird, for example, and you spend half your time in Florida, that's a more complicated plan.
So how long does it take for a Medicaid application to be reviewed and approved?
Well, generally, and again, I say this with some caveat because COVID-19 has changed the timetable for everything. But generally, a home care Medicaid application that is not complicated is in Nassau County is processed in about 1 to 2 months tops from beginning to end, and that's including the eligibility, which we've been talking about, and actually getting the care in place, which we haven't touched on yet. But so I would say, a good estimate is about 1 to 2 months in Nassau County for home care Medicaid. For nursing home Medicaid, my experience has been it's been similar, but the more transfers you make, the more complicated your application is, the more that has to be reviewed during that 5-year audit period, the longer that application is going to take.
Mm-hmm. And I want to reiterate to everyone watching again, Frank has a lot of information here. So if you have any questions, please feel free to type them in and we'll go over as many as we can. And this webinar is recorded and everyone will receive an email with Frank and Stephanie's contact information for any additional specific questions that we may not touch on today. So Frank, I have some specific questions or a few questions here that I'd like to bring up to you. Someone asked, I'm a senior with low income on Social Security, but I got denied for Medicaid. Why is that?
Right. Well, the thing you want to understand is when you apply for Medicaid, you get a formal written denial. So anybody who applies for Medicaid anywhere in the state of New York will receive a formal written denial that explains the reason for their denial. So that person should have that written denial. And in order to understand why they were denied, you'd have to look at the reasoning given in that decision. Sometimes what happens is people don't provide the information that Medicaid requires, and so they deny the application for failure to submit the proper documentation required that is necessary to determine eligibility. Sometimes they don't provide adequate or accurate information about their assets and their income. And so Medicaid has a wrong understanding about what their actual financial situation is. But where you want to start with that kind of denial, because I have no way of knowing what the reason is look at the threshold numbers that I gave you already, $15,900 in assets, and an income of no more than $890 a month, and then look to see what the written decision says about the reason for the denial. You have a right to appeal that, but you have to do it within a certain prescribed period of time, usually no more than 60 days from the date of the denial. So it's important to remember, once you receive your written decision, whether it's positive or negative, you have a right to appeal that by asking for what's called a fair hearing. And in that written decision, they tell you where you can call to ask for your fair hearing. And nowadays, many of those are being done via Skype, just like this lecture is being done. So it's gotten a little easier, but you certainly should consult with an expert if you've gotten a denial and it looks like you haven't had proper representation and you're not getting the benefits you deserve and are entitled to.
Now, someone asked, can I have an elderly parent qualify for Medicaid without going through social services?
Right. So you have to apply for Medicaid in the local social service, the county agency that administers the Medicaid program. So every county in the state of New York administers their own particular Medicaid program that's overseen or managed by the state of New York and then receiving funds from the federal government. But you must go through that Department of Social Services agency to apply for Medicaid. Nowadays, you can't actually physically go into the, for example, Department of Social Services in Nassau County because of COVID-19. You have to drop the application off at the entrance to the agency. But the quick answer is you must apply. I think you can get the application online. If somebody needs an application and they're not able to get it, they can certainly call my office and we'd be happy to send them one. And then you submit that application to the local county Department of Social Services. In New York City, it's called the Human Resources Administration. It's not a county social service department.
Mm-hmm. Okay. Another question about, can you explain the concept of spousal refusal in New York State?
Sure. Okay. So remember before we talked a little bit about spouses having special preferential treatment with respect to the transfer of assets.
Yep.
Spouses also have rights to income that belongs to their spouse under various laws in New York, domestic relation law and the Family Court Act. But there is a special provision of the social services law that oversees Medicaid that says, excuse me, that says spouses can refuse to make their assets and income available when their spouse is applying for Medicaid. And that's what the spousal refusal is. It's a formal notice that's signed and notarized, that's submitted at the time of the application for Medicaid, where the spouse says, I'm unable, for whatever reason, to make my income and assets available for my spouse's Medicaid benefits. And by law in New York, the application needs to be processed then solely based on the income and assets of the applying spouse. Now, what people need to understand about the spousal refusal is that is part one of the equation for eligibility. So if you're in a situation like that, you submit your spousal refusal, your spouse must get the benefit solely based on their income and assets. What used to happen, and theoretically what still can happen, although it's not being enforced, is the county can look at the non-applicant spouse's income and assets and say, wait a second, you have substantial assets in your name and you have a substantial income. So as a spouse, we're going to require that you contribute towards your spouse's care. We'll give you the Medicaid, but you're going to contribute X amount of dollars based on your own income and assets. Now that's a policy question that the counties and the state apply, and it's not always enforced, and right now it's not enforced. But it's important when people sign their spousal refusal documents that they understand the full implications of that, and that's something their attorney would advise them on.
Okay. I do have a few more questions here, unless there's something else, Frank, that you wanted to focus on that maybe we didn't touch on yet that you feel was important to communicate today.
Well, I mean, two things I just want to bring to your everybody's attention, because Sky mentioned it before. We have elder care guides that are prepared that if anybody wants a copy, that gives an overview of nursing home Medicaid and home care Medicaid and the pooled trust, et cetera. If you contact me by email or call the office, we'll send it out to you for free, and it'll give you a reinforcement of what we discussed and touch on a lot of the issues that we didn't get to, because you really need to devote a substantial amount of time just to the Medicaid alone. Now, the home care Medicaid, we talked about nursing home Medicaid at the beginning, so I just want to quickly touch on the home care because it's important. Home care traditionally did not have that transfer restriction on assets that nursing home does. That 5-year look back does not apply to home care Medicaid in New York. There is currently no look back period, no penalty period for transferring assets in New York. But there is a new rule that is a new law going into effect as of April 1, where there will be a 30-month look back as opposed to a 60-month look back for people who transfer assets and are applying for home care Medicaid. So it's important for people to be aware of that. And if they're inclined to do this kind of Medicaid planning right now, they may want to do it quickly and get around the need to document 30 months of their assets and risk getting a a penalty period imposed, because that rule will go into effect April 1. It originally was intended to go into effect last April, but because of COVID-19, the state has delayed it several times. But I haven't heard that they're delaying it any farther than April 1 of this year. So it's important to know that currently there's no look back period or penalty period for transferring assets for home care. That rule only applies for nursing home care, but there will be a rule applied beginning April 1 that will have a 30-month look back and a penalty period associated with transfer of assets, just like for nursing home. The same rules for spouses will apply. So there'll be exemptions for transfers to spouses, disabled children, etc.
Okay, great. And you said you could email everyone some materials that maybe would answer a lot of the outstanding questions here and really give an overview, because as we noted, this topic is very dense and complicated, and it's also sensitive for a lot of families. So it's important, like you said, to sit down and really digest it.
Right. There are several major pieces to this planning. There's obviously the legal planning that you need to consult with your attorney about. There's the healthcare management piece of it, which is very important, which we weren't able to touch on, but just quickly, so people understand, once you qualify for Medicaid financially, the next piece is Medicaid will send nurses out to determine whether you qualify or you need home care services. And if you do need home care services, how many hours are they going to provide to you? And so that becomes another layer of advocacy, because the tendency is for the agencies, they're called MLTCs, managed long-term care agencies, to not want to provide sufficient hours to patients. So a lot of advocacy, a lot of detailed evaluation needs to be done to really make the case for the home care services, particularly if somebody is in need of 8, 10 hours, 12 hours, or even live-in care. And so people need to be aware of that piece to it as well. So yes, I concur with what you're saying, Sky. That is that these are complicated issues and there are many moving parts, and it's really why you need to seek professional advice from the appropriate professional when you're faced with this kind of situation. But the good news is that there are very good solutions if you find the right people to help you.
Right. And that's why we do these types of webinars with Herald Community Newspaper Group, is to really highlight some of the experts in the community, like yourself, Frank, and like Stephanie, and they're the experts. So we bring them to you through this webinar series.
All right. Well, if there are no other questions, I thank you for inviting me today, and I look forward to the responses from your audience and questions and an ongoing dialogue.
Okay, great. Fantastic. Yes. Someone just asked for your email address. Today's webinar is recorded. We will send it out to everyone, and we will provide everyone with both Frank and Stephanie's email address. So for any outstanding questions, you can contact them directly. And Frank said he'll share that some materials for everyone. And we really thank Frank and Stephanie for their time today. And thank you on behalf of the Herald and my team. And thank you to our panelists. And thank you everyone for joining.
Thank you. Stay safe.
Yes, stay safe, everyone. Stay safe. Thank you.